This is Jim Lang. This is the second in a series of videos about the Secure Act and the massive income tax acceleration that unfortunately IRA and retirement plan owners and their families will suffer in the event they do not take proactive steps to avoid it. So in the first video we talked about the massive income tax acceleration and how it might make a difference between your child being broke and your child having $2 million. But I also said that there were some very important exceptions to the Secure Act. So this video will focus on those exceptions. The most important exception is your surviving spouse. That is, you can leave your IRA or your retirement plan to your surviving spouse, and your surviving spouse can then use the old laws, that is the pre-January 1, 2020 laws, where they could take no minimum required distribution until 72, and then after 72, take a minimum required distribution based on their age and the age of somebody 10 years younger, which is consistent with the old law that allowed your surviving spouse to have a significant stretch of the IRA or deferred income tax after your death. So that's the most important exception. The other very important exception is a charitable remainder trust. We're going to do a whole video. Actually, we have a whole chapter, chapter 8 of our new book, Beating the New Death Tax, on the charitable remainder trust. And if you have a substantial IRA, probably very worthwhile to read chapter 8. But anyway, the reason why the charitable remainder trust can actually provide more money to your child or children than if you leave it to them outright is because it is one of the exceptions to the massive income tax acceleration. The other exceptions are in the event that the beneficiary is disabled or chronically ill. By the way, I'm speaking from personal experience now because we have a daughter who is disabled. And here's the key. The exception basically treats the disabled child just like a child before the new tax laws, meaning that the disabled beneficiary could stretch or defer that income tax for the rest of their life. Now, it's also very important if that money is going to go into a trust, that the trust must meet the 5 specific conditions in order to qualify as a designated beneficiary, and that it also must meet the requirements that you want to protect that trust from government creditors in the event that the child or beneficiary is getting any type of state or federal government benefit. But anyway, the basic exception is the child can treat the IRA just like they could under the old law. But here's the kicker. You must prove the disability. And what we have found, and it's certainly true in our house, it would have been extremely difficult for our daughter to prove her own disability. Not because she isn't bright enough or that she wouldn't be able to do it, but what happens with a lot of disabled beneficiaries is they can't get certain chores together. And it's really, I think, much better if you have a disabled or chronically ill child to get the proof of that while you're healthy, while everything's fine, and then if something does happen, you're already, let's say, grandfathered in, if you will, although you can have, let's say, a return to health. But the basic idea is you want to get this done beforehand while everybody, or while you are still capable of doing this. This is critically important. It can be the difference, again, we talked in the first video, between your child having 0 and your child having $2 million later in life. And if you're talking about a disabled or chronically ill beneficiary who probably can't have a productive career, this becomes a huge factor in the quality of life for any disabled beneficiary or chronically ill beneficiary. There's some other exceptions too that relate to in the event that your beneficiary is less than 10 years younger than you, more likely a sibling or maybe an unmarried spouse. There's also exceptions in the event that your beneficiary is very young, like perhaps a grandchild. But even then, after the age of majority, the 10-year clock on the income tax acceleration starts ticking, so it's not a complete exception. But anyway, utilizing these one or more of these exceptions could just make an enormous difference in the life and the financial security of you and your family. So if you've not already done so, I would highly encourage you to purchase our new book, Beating the New Death Tax by James Lang. If you have purchased it, I would actually read it, or at least read parts of it, table of contents, overview, the chapters that are most relevant, and then more importantly than even just reading it is actually taking action, whether it's on your own, whether it's with the help of our firm, and there's some offers to see if you are a good fit to work with us in the book, or even somebody else. But don't do nothing. This is a serious threat to your livelihood, to your financial future, to your legacy. Please do something to protect your family from the dreaded Secure Act. Thank you.